How you guys doing? My name's Chris Padovano, and I'm an attorney from New York. I am the founder of Decentralized Legal and have built my entire legal practice around blockchain businesses. I currently work as counsel for MakerDAO and sit on the board of directors at Steemit, the creators of the Steem blockchain. Just by a show of hands, how many of you guys are developers here? Excellent. Well, I hope that at least part of what I'm going to talk about today will be useful and instructive for you. So I spend the majority of my time working with developers who want to ensure the longevity of their projects as the law evolves over time. While I can't predict with any certainty how future legislation will impact dApps and DAOs like Maker, I can share with you some practical advice on certain issues that I believe you should all be aware of. This afternoon, I'm going to speak about 3 important legal principles: fiduciary duties, decentralization, non-hierarchical and more democratic legal structures. So first, let's talk about fiduciary duties. In the broadest sense, a fiduciary is a person who holds a legal or ethical relationship of trust with one or more parties. Typically, a fiduciary is entrusted with the management of money or assets on behalf of another person. The concept of a fiduciary and its resulting obligations originated in England in the latter Middle Ages. In the early days, the fabric of English common law provided for the strict enforcement of statute by judges, and that often led to unfair and unjust outcomes. Those skilled in law could and did use their knowledge to their own advantage, sometimes with perverse results. Judges enforced the applications of rules even in the most harsh of circumstances that cried out for exception. Only when a competing legal framework was developed by courts of chancery or equity outside of the common law to address one basic concern: to prevent persons with discretionary power over interests of others from abusing that power to improperly benefit themselves. In our daily lives, we regularly take for granted the ubiquitousness of fiduciary duties as we interact with our financial world. Today, the definition of fiduciary duties has expanded to include many different roles, actions, and industries. As a result, a whole host of financial actors are required to disclose conflict of interests that they may have when selling you a new product. Public companies must disclose beneficial ownership information. So-called insiders are prevented from trading on their exposure to material, non-public information. One of the promises of blockchain finance is the development of a better, fairer, more transparent financial system. In its current state, however, blockchain software is still relatively primitive and requires great expertise to provide guarantees across a distributed system. As your projects and teams grow and become public-facing, there are some important considerations that you should familiarize yourself with regarding fiduciary responsibilities that you may have towards your users, towards your supporters, and towards your partners. Some important steps you can take is: 1, if you have a native token in your ecosystem, consider speaking to counsel about the anti-fraud and market manipulation rules you may find yourself dealing with if your token is trading on secondary exchanges. 2, identify conflicts of interest you may have with respect to financial or informational asymmetry with your community or users. Disclose and remove any such conflicts as quickly as possible. 3rd, on a frequent and regular basis, you should provide all material information to your community as it relates to the features and use of your dApp and token. At the same time, you should be actively reviewing public-facing communications so that you're consistently emphasizing your token's functionality rather than its resale value. The bottom line is that it's important to think about how your organization might be acting as a fiduciary. This is crucial because if you don't, you may find yourself with limited options to remedy legal problems with your dApp or product. You know, the old Mike Tyson standard is everyone has a plan until they get punched in the face. So thinking about fiduciary and responsibilities now can prevent you getting punched in the face and not having a plan and getting a TKO from a litigious third party or from a regulatory body like the SEC. Another issue that has extensive legal implications for blockchain projects is that of decentralization. dApp developers looking to bootstrap their networks via a token sale or an airdrop must confront the risks that their distribution and their roles in that distribution could color their token as a security, opening the door to potential securities law liability and onerous legal requirements that could leave your project incapacitated. Those of you interested in shielding your projects from such scrutiny may want to consider looking into well-settled registration exemptions via the private placement regime or Reg S before going forward with any distribution event associated with your token. In the broadest terms, the more decentralized your project is, the less likely that a regulator or some litigious third party will have a basis for claiming that your token represents a security through an investment contract analysis. You may already be familiar with the Howey investment contract analysis, but here's a brief overview. An investment contract is a type of security and is a specific type of legal construct that underscores that not every security will look like a traditional bond or shares of equity. Under Howey, an investment contract requires the presence of an investment of money into a common enterprise where a purchaser has a reasonable expectation of profit from the efforts of a third party. So if an issuer, seller, promoter, or underwriter, or some affiliated third party is selling an instrument to purchasers who have a reasonable expectation of profit from the endeavor based on the efforts of others, then it's very likely that that instrument will be classified as an investment contract. One of the most efficient ways to immunize your project from securities law risk is to ruthlessly pursue the decentralization and distribution of authority to the greatest extent possible. If no one single person can be said to have an outsized influence on your network, or the failure or success of your project, then it will be much more difficult for anyone to claim that purchasers can have a reasonable expectation of profit and through the essential managerial or entrepreneurial efforts of their actions. And therefore, it stands to reason that your token is not an investment contract subject to securities regulation. Don't underestimate the high bar and models of authority necessary to achieve the decentralization required to swat back at an investment contract analysis. In my opinion, the hallmark of a truly decentralized project is when the token creator no longer has control of the network, including foregoing his or her ability to make unilateral changes to the functionality of the token. Some further hallmarks of a truly decentralized project are when the greatest number of network nodes are controlled by the broader community, when the code is forkable and open source, or based on a permissionless network where any node or participant can join. With these hallmarks of decentralization in mind, when designing your DApp or building out your product and putting a token into your ecosystem, some questions that you will still need to answer include, do users actually require the token? And is its function commensurate with any of their needs? Is your token part of the core functionality of your project outside of raising capital? Do you have a governance token? Well, what does that governance token look like? Do you have everything worked out, or are there still material open questions about how your project will respond to the demands of your community? Are the tokens distributed in ways that meet users' needs? For example, can tokens be held or transferred only in amounts that correspond to a purchaser's expected use? Are there built-in incentives that compel using the tokens promptly on the network as opposed to tokens that can be held for long, extended periods of time? Is your application functional, or are you still in the early stages of development? Those are admittedly a lot of questions to ask yourselves, and quite a lot to consider. While becoming a truly decentralized project is certainly not without its challenges, I believe that it could be extremely worthwhile for you and your projects in the long run. Here's a nice little quote from Bill Heinemann of the SEC, kind of talking about why he believes that the current state of Ethereum or Ether is not a security. So the final principle that I would encourage you all to consider when developing your individual projects is to examine the viability of more democratic and flat legal structures. However, I do understand full well that this is not going to make sense for every project. The open and public nature of blockchain-based networks precipitates the re-examination of some basic legal principles. For instance, what do we mean when we say that we own digital tokens that sit in our wallets? The ownership and control of a private key associated with an account would obviously constitute ownership, but throw that token into a multisig and fundamental questions concerning title still remain unanswered. It is my position that if we are questioning some of the most banal of legal constructs as they relate to property and ownership for blockchain-based assets, then perhaps we should also be scrutinizing the traditional corporate forms to which founders and investors have become accustomed. For decades, entrepreneurs have relied on the corporation as their vehicle of choice for their businesses, and for good reason. Corporations permit entrepreneurs to quickly organize a company, use forms like SAFEs, SAFs, and notes, and gradually begin the process of scaling their corporations with the ultimate goal of either selling their business or going public. Sometimes distributed systems like dApps do not fit neatly within the rigidity of the corporate form, especially when the incentive structure of a network does not have such an intense focus on the maximization of profits for shareholders. Open and decentralized systems and applications require fluidity and flexibility for different types of collaborative efforts. For those of you who are not planning on ultimately going public, you may find an exciting avenue in exploring the benefits of structuring your project as either a cooperative or a commercial foundation. Member-owned cooperatives or member-managed commercial foundations could provide your team with a more democratic organizational structure that reflects the values of your team and project. Outside of the specific use of less monolithic and more collaborative types of organizations, I would like to expound on even how arm's-length competitors could come together and to achieve shared goals via some non-hierarchical organization, such as a cooperative. Right now, we have a huge problem with wash trading exchanges and wholesale market manipulation across overseas exchanges. You don't need to have a deep technical expertise to see that the reference volumes on some overseas exchanges are fake. That's a big problem. These exchanges undermine the entire premise of blockchain-based finance by obfuscating the true liquidity and price discovery of blockchain-based assets. Across the board, liquidity is mostly fragmented. Pooling resources and other types of liquidity would be both locally beneficial to liquidity providers and traders, as well as globally beneficial to the entire space. The organization of a member-owned cooperative for market makers may be best situated to start developing standards that seek to root out this fraudulent behavior. So if you're a trader or a market maker or have any interest in trying to mitigate some of the fraud that's happening on these exchanges, I'd love to talk to you. I know that was kind of a quick shot of a bunch of law and some of my rambling thoughts. But I'd like to thank BuildETH for inviting me here today. I'd like to thank the MakerDAO team for being here in full support. And I'd like to wrap up with just one more piece of advice. I would encourage you all to internalize the principles of honesty, integrity, prudence, and fairness across all levels of your organization and the products that you breathe life into. Personally, I believe that we will never displace the current financial system with its crony capitalists, economic inequality, and opaqueness if we do not, from first principles, take extraordinary effort to make sacrifices to be better and to build fairness into the guarantees that no doubt you all desire to provide to your organization and communities. So that's all I got. But if anyone has any questions, shoot.